Groh v. Ramirez, Supreme Court, 2004. Justice Stevens delivered the opinion of the court. Petitioner conducted a search of respondent's home pursuant to a warrant that failed to describe the persons or things to be seized. The question presented is whether the search violated the Fourth Amendment. Footnote: there was also an issue of whether the officers could be held civilly liable for relying on such a warrant. The specific question was whether they violated clearly established law that the reasonable officers should know. This is omitted from the opinion footnote by the case authors. 1. Respondents Joseph Ramirez and members of his family live on a large ranch in Butte Silver, Bow County, Montana. Petitioner Jeff Groh has been a special agent for the Bureau of Alcohol, Tobacco, and Firearms since 1989. In February 1997, a concerned citizen informed petitioner that on a number of visits to the respondent's ranch, the visitor had seen a large stock of weaponry, including an automatic rifle, grenades, a grenade launcher, and a rocket launcher. Based on that information, petitioner prepared and signed an application for a warrant to search the ranch. The application stated that the search was for any automatic firearms or parts to automatic weapons, destructive devices to include but not limited to grenades, grenade launchers, rocket launchers, and any and all receipts pertaining to the purchase or manufacture of automatic weapons or explosive devices or launchers. Petitioner supported the application with a detailed affidavit, which he also prepared and executed, that set forth the basis for his belief that the listed items were concealed on the ranch. Petitioner then presented these documents to a magistrate along with a warrant form that petitioner had also completed. The magistrate signed the warrant form. Although the application particularly described the place to be searched and the contraband petitioner expected to find, the warrant itself was less specific. It failed to identify any of the items that petitioner intended to seize. In the portion of the form that called for a description of the person or property to be seized, petitioner typed a description of respondent's two-story blue house rather than the alleged stockpile of firearms. The warrant did not incorporate by reference the itemized list contained in the application. It did, however, recite that the magistrate was satisfied the affidavit established probable cause to believe that contraband was concealed on the premises, and that sufficient grounds existed for the warrant's issuance. Respondents sued petitioner and other officers. The district court entered summary judgment for all defendants. The court found no Fourth Amendment violation. 2. The warrant was plainly invalid. The Fourth Amendment states unambiguously that no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. The warrant in this case complied with the first three of these requirements. It was based on probable cause and supported by a sworn affidavit, and it described particularly the place of the search. On the fourth requirement, however, the warrant failed altogether. Indeed, petitioner concedes that the warrant was deficient in particularity because it provided no description of the type of evidence sought. The fact that the application adequately described the things to be seized does not save the warrant from its facial invalidity. The Fourth Amendment, by its terms, requires particularity in the warrant, not in the supporting documents, and for good reason. The presence of a search warrant serves a high function, and that high function is not necessarily vindicated when some other document somewhere says something about the objects of the search, but the contents of that document are neither known to the person whose home is being searched nor available for her inspection. We do not say the Fourth Amendment prohibits a warrant from cross-referencing other documents. Indeed, most courts of appeals have held that a court may construe a warrant with reference to a supporting application or affidavit if the warrant uses appropriate words or incorporation, and if the supporting document accompanies the warrant. But in this case, the warrant did not incorporate other documents by reference, nor did either the affidavit or the application, which had been placed under seal, accompany the warrant. Hence, we need not further explore the matter of incorporation. Petitioner argues that even though the warrant was invalid, the search nevertheless was reasonable within the meaning of the Fourth Amendment. He notes that a magistrate authorized the search on the basis of adequate evidence of probable cause, that petitioner orally described to respondents the items to be seized, and that the search did not exceed the limits intended by the magistrate and described by petitioner. Thus, petitioner maintains his search of respondent's ranch was functionally equivalent to a search authorized by a valid warrant. We disagree. This warrant did not simply omit a few items from a list of many to be seized or misdescribe a few of several items, nor did it make what fairly could be characterized as a mere technical mistake or typographical error. Rather, in the space set aside for a description of the items to be seized, the warrant stated that the items consisted of a single dwelling residence, blue in color. In other words, the warrant did not describe the items to be seized at all. In this respect, the warrant was so obviously deficient that we must regard the search as warrantless within the media law. We are not dealing with formalities, because the right of a man to retreat into his own home and there be free from unreasonable governmental intrusion stands at the very core of the Fourth Amendment. Our cases have firmly established the basic principle of the Fourth Amendment law that searches and seizures inside a home without warrant are presumptively unreasonable. We have clearly stated that the presumptive rule against warrantless searches applies with equal force to searchers whose only defect is lack of particularity in the warrant. Petitioner asks us to hold that a search conducted pursuant to a warrant lacking particularity should be exempt from the presumption of unreasonableness if the goals served by the particularity requirement are otherwise satisfied. He maintains that the search in this case satisfies those goals, which he says are to prevent general searches, to prevent the seizure of one thing under a warrant describing another, and to prevent warrants from being issued on vague or dubious information, because the scope of the search did not exceed the limits set forth in the application. But unless the particular items described in the affidavit are also set forth in the warrant itself, or at least incorporated by reference in the affidavit present at the search, there can be no written assurance that the magistrate actually found probable cause to search for and to seize every item mentioned in the affidavit. In this case, for example, it is at least theoretically possible that the magistrate was satisfied that the search for weapons and explosives was justified by the showing in the affidavit, but not convinced that any evidentiary basis existed for rummaging through respondents' files and papers for receipts pertaining to the purchase or manufacture of such items. Or, conceivably, the magistrate might have believed that some of the weapons mentioned in the affidavit could have been lawfully possessed and therefore should not be seized. The mere fact that the magistrate issued a warrant does not necessarily establish that he agreed that the scope of the search should be as broad as the affiant's request. Even though petitioner acted with restraint in conducting the search, the inescapable fact is that this restraint was imposed by the agents themselves, not by a judicial officer. We have long held, moreover, that the purpose of the particularity requirement is not limited to the prevention of general searches. A particular warrant also assures the individual whose property is searched or seized of the lawful authority of the executing officer, his need to search, and the limits of his power to search. It is incumbent on the officer executing a search warrant to ensure the search is lawfully authorized and lawfully conducted. Because petitioner did not have in his possession a warrant particularly describing the things he intended to seize, proceeding with the search was clearly unreasonable under the Fourth Amendment. The Court of Appeals correctly held that the search was unconstitutional.